first case to come before the court today is in re AG and EG. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, let me know and I'll try to alert you to when you're going into that rebuttal time. The arguments are being recorded, so please stay behind the podium, introduce yourself, keep your voices up. You should not use the names of children or victims or minors. You can use initials or generic terms like the child, the children. We have read your briefs and we're ready to proceed when you are. So I would just ask appellant, would you like to reserve time?
Yes, Your Honor, I would.
And how much time would you like?
I would reserve 5 minutes, please.
Okay, very well. Then we are ready to go when you are ready.
Good morning, judges, and may it please the court. My name is Angelina Jingo, and I represent the appellant mother in this case, Erica Stripmatter. I identified 3 primary issues in this case in my brief: whether the trial court's decision was not supported by sufficient evidence and was against the manifest weight of the evidence in granting Children's Services motion for permanent custody and not granting mother's motion for a 6-month extension. Second, whether the trial court committed plain error and reversible error when it terminated the parents' rights and placed the children in the permanent custody of the agency, when the agency, we assert, did not provide mother with reasonable reunification efforts. And third, whether the trial court committed plain error and reversible error when it did not continue the appointment of an attorney for the children after the children enjoyed visits and expressed an interest in visits. First, regarding the issue of substantial case plan compliance, we submit that mother did complete substantial case plan compliance at the time of the permanent custody trial. No extension was ever granted in this case to allow mother additional time. I would point to page 3 of the decision where it states that mother failed to engage in mental health counseling. I would urge the court to look at this assertion. A substance abuse disorder is a mental health diagnosis. Between April and October of 2023, mother engaged in 10 counseling sessions. She submitted to counseling when her counselor wanted. She came for the full hour. She was engaged, and there were constraints from Community Health Center that could not allow those sessions to be more frequent. But my point is mother nevertheless complied. In the counselor's testimony, she indicated that mother was consistent. She completed 18 drug screens, all were negative. There was also some testimony that mother was prescribed medications through Summa Behavioral Health. I also wanted to use this argument to reply to Children's Services brief. Mr. Campbell pointed out that there was a bipolar diagnosis in the Phoenix records, which is Exhibit 4 in the transcript. And I would concede that there is a note in the discharge summary that says that there was a bipolar diagnosis and there was a post-traumatic stress disorder diagnosis. But I would also point out that through the counselor at Community Health Center, with whom she had 10 visits, 10 hours of treatment, she never came to this diagnosis. And not only this treating counselor, but also an assessing counselor. The assessment is also in the Community Health Center records. And there was no diagnosis for bipolar disorder nor post-traumatic stress disorder in those records. I think it's interesting that Children's Services wants to point out that there were these other 2 diagnoses in this Phoenix Rising records, but I would also urge the court to look at that discharge summary in Exhibit 4 says other stimulant abuse, in remission, but mother still did substance use treatment that was still included on her case plan. So I submit that the position is simply not consistent. We can't say, well, these records say one thing, that mother has these diagnoses and they weren't treated, while at the same time requiring her to submit to substance abuse treatment, which she did. And she tested negative consistently, and she engaged in counseling. There's this constant kind of, I would say, war between substance use treatment and mental health treatment in this juvenile justice system. And I submit that they are not as clear-cut as they might sound. I submit that these substance use disorders are all under the umbrella of mental health. And Miss Christine Head, in her testimony, she alludes to this. She says, the services at Community Health Center were dual diagnosis, which address both substance use disorders and mental health concerns. And I point to this in my brief, but I wanted to reiterate it, that Ms. Head said that perhaps mother could address her mental health a little bit more, but that she seemed stable. That was in her testimony at the permanent custody trial.
Counsel, I know there were all kind of counseling records that both sides talked about and so forth, and testimony in regard to that. Was there any testimony in regard to a psychiatrist?
I do not believe there was testimony regarding a psychiatrist. But I would also point out that, and this goes somewhat to, in my mind, the reasonable efforts issue, there was some discussion about mother's treatment at Summa, and I believe mother had signed a release, and the agency was working to get those records, and the caseworker testified that she sent the release once and made a call once. And I submit that that is not enough. That is simply not enough when we are looking at the termination of parents' parental rights. I would also point to the Community Health Center records that say that mother learned and implemented personal coping strategies to manage stress and prevent relapse. So there's an element of drug abuse treatment there, but also coping strategies, which are more just general mental health. Objective 11 said mother should learn and implement problem-solving strategies for realistically addressing worries and depressive symptoms. There's nothing in there about substance use treatment. Intervention 1 was to assess the client's frequency, intensity, duration, and history of panic and depressive symptoms, fear, and avoidance. I don't hear the word abuse in there at all. Also relating to mother's substantial case plan compliance, mother was, at the time of the trial, mother was employed. Mother had obtained a Section 8 voucher, but had experienced trouble securing housing due to some credit issues. I would turn to the second real error that I assigned regarding reasonable reunification efforts. Mother's visits were never expanded beyond 2 weekly hours and in a closely supervised setting. Despite the counseling efforts that she made, despite this negative substance abuse treatment, despite the involvement with the Bear Foundation, page 3 of the decision also states that mother did not see the need for parent education, but she engaged. I also point to the timeline in that mother was initially evaluated by Bear on August 11th of 2022, and a service plan was not signed until March. Now, there is some statements in the transcript that state that mother could not be reached in January, but if I had contacted a doctor's office for a referral and I didn't hear back for 4 months, I think we all might question who's calling me or where are we coming from.
I know you're almost into your rebuttal time, so let me make this quick. What is your response to the obvious impact that Mom's testimony had? In other words, the trial court said, in listening to her testimony, observing her demeanor, very concerned about the prospect of returning the kids to her or continuing the case.
Sure. I do think that the trial court's perception is obviously very valuable, but I would submit that testimony and being cross-examined at a stressful time can be difficult for a parent. And I would point back to Miss Christine Head's testimony at Community Health Center that mother seemed pretty stable in sessions there with her when she wasn't being cross-examined.
And you have moved into your rebuttal time, you're at 4:31.
Okay, I will reserve the room.
Very good,
Thank you.
thank you. No,
I have a lot of explanations.
no, okay, we appreciate your presence, but we have to just keep the talking to the attorneys. Thank you. Counsel?
Thank you, Your Honor. May it please the court. Good morning. My name is Aaron Campbell. I represent Children's Services in this matter. And Children's Services asked this court to affirm the decision from the trial court that granted permanent custody to Children's Services of these 2 children. This decision was not against the manifest weight of the evidence, nor were the other errors raised by mother arise to plain error in this case. First, regarding the manifest weight of the evidence here, the court made a correct decision regarding the first prong of permanent custody, in that the court found that parents could not remedy these problems within a reasonable time. Now, regarding the father, there was no dispute in this case that the father at the time of the permanent custody trial was incarcerated and was not going to be available within a reasonable time due to the domestic violence issues that occurred as a result that started this case.
Which Mom was not involved with at all.
That is correct, Your Honor. She was not involved, but she was not involved because she did not have custody of those children at that time. There was ample evidence submitted to the trial court that the mother had struggled, had a long struggle with mental health concerns, and that law led to the loss of custody of these 2 children in particular at their birth. They ended up being placed in their father's custody following the course of that juvenile case at that time. The records also demonstrate that the mother had lost permanent custody of siblings of these children due in part to significant concerns, specifically regarding bipolar disorder.
And CBS didn't ask for a bypass.
That's correct, Your Honor. The agency did not ask for a bypass, and that was also not included as a grounds for an E factor in the decision for the trial court. However, it is evidence demonstrating the mother's mental health concerns. This is not a recent concern for the mother. This shows that she has had a long-standing issue with bipolar disorder and other mental health concerns.
Well, let me ask you about that bipolar disorder. Was there, the counsel for mother says that there's no record that she is aware of that CSB required her to see a psychiatrist and/or that any evidence was presented about a psychiatrist. Is that correct?
I don't recall any requirement specifically for a psychiatrist. The case plan did require that she maintain her mental health services. When this case began, she was already engaged with the Phoenix services, and that service had diagnosed her with bipolar disorder and post-traumatic stress disorder. So the agency was willing to work with her and her provider at that time to continue to address those concerns.
Was there any testimony as presented about any medication that she might have been taking?
My understanding is that the agency was not able to obtain the information about medication. The mother had claimed she was going to Suma Health for medication services. The agency requested that information but was not able to obtain it.
Well, did anybody ask her at the hearing?
I don't recall if that information was provided, Your Honor. That was, my understanding was that was not able to be confirmed through subsequent requests through Suma Health specifically.
The reason I'm bringing it up is because obviously the agency is very concerned about the mental health aspect of it. And if mom has been diagnosed with a bipolar disorder, then that's is treatable or should be treated with medication. So I'm just wondering what information was available in regard to that.
It seems like there was very little information available for that. The agency had expected her to continue in services with Phoenix. However, the records from that agency demonstrate that she stopped attending services there due to non-compliance with their requirements. The mother claimed that she was going to mental health services then with Suma in addition to receiving her medication records. Children's Services asked for that information, but it seems that that information didn't exist. And I would note that the counselor from CHC had testified that she had deferred to Suma under the belief from the mother that she was getting these mental health services to address those specific mental health diagnoses with Suma, but then the mother had later admitted to her CHC counselor that she was not getting those mental health services with Suma. So the counselor from CHC was under the belief that she was getting those addressed with a separate agency. The CHC treatment was primarily designed to address the substance use concerns, which in this case was a relapse on methamphetamine in December of 2022. So the CHC services did not really focus on those mental health concerns from those other diagnoses from the other agencies, but where the mother had a long history of presenting concerns due to those mental health diagnoses. So the first prong was proven by clear and convincing evidence at the trial court, because the court found credible evidence that these problems could not be remedied within a reasonable time. Now, into the second prong, there was clear evidence presented that this was a permanent custody decision was in the best interest of these children. As I stated before, the custodial history shows that the mother was not involved with these children for the nearly 10 years since their birth. The father had custody of these children. When that case closed originally, there was a no contact order with those children. The mother had to go back to court in order to obtain visitation, but it seems like that never occurred, and the mother had no relationship with these children.
Well, she did go back to court for visitation, but only a couple of years ago, right?
That's correct, Your Honor. She did go back and obtain visitation, but it seems from the testimony that even after obtaining that order for visitation, that never happened with these children. The children did not know the mother as their mother. They believed the father's paramour was their mother, and they had a strong relationship with the father's paramour. So much so that when this case began, they believed they wanted to be in the custody of their father's paramour. However, due to the concerns with the father and the domestic violence there, it seems that she was not willing to take custody of these children. So the other option the children presented was that they were willing to remain in the foster care home where they had been placed since the onset of this case. And neither child expressed an interest to be placed in the custody of their mother. So there was no conflict of interest in this case presented either. The trial court, the guardian ad litem specifically raised that issue prior to the permanent custody decision, that there may have been a conflict. The court reappointed an attorney to represent the children. However, the record shows that there was a soliloquy between that attorney and the court. The attorney stated that she had spoken to the children. She found there was no conflict. The children did not want to live with their mother. And there was no objection from any of the parties to excusing that attorney from representing the children. The guardian ad litem had recommended permanent custody of the children so that they could remain in the foster care home where they had developed a strong bond with the foster family.
How long had the children been in custody whenever the permanent custody motion was filed?
The children were removed in March, and the children were then, the permanent custody motion was filed the following January. So it had been roughly 10 months that they had been in that foster home in the agency's care.
Why the rush?
They are are you
Well-
referring to filing it 2 months before the sunset?
I was gonna say, usually one of the things that CSB seems to hang its hat on is a 12 or 22.
In many cases, that would be correct, Your Honor, but even the agency is required to file its permanent custody motion 30 days before the sunset. So at the initial sunset, 12 of 22 can never apply for that initial sunset because the motion has to be filed at least 30 days before the sunset, so the agency could never have 12 months of custody at the first sunset hearing. And at least in this case, with the father's incarceration and the long history that the agency was aware of the mother's mental health issues, it seemed that it was not likely that these concerns, these issues that led to the removal of the children was going to be remedied. And so the agency had only filed the permanent custody motion roughly 2 months before the sunset.
So you seem to be saying that your main focus, CSB's main focus, was not on the drug usage, because she seemed to be, doing relatively well with that. She was diagnosed as being in remission.
Yeah, I believe there was, with the Phoenix records, there was a note of remission. However, there was a relapse in December of 2022.
Which is very usual with drug abuse, right?
That is correct, Your Honor.
Okay.
Relapse is a part of recovery, that is common knowledge at this point, but the agency would concede that there were no issues within the record that other than the relapse, that the mother was otherwise complying with the substance use objective. The paramount concern in this case was the mental health objective, which was not being addressed through treatment and the basic needs objectives, which I think the mother had even admitted during her testimony that her home was not appropriate. She was looking for other housing, but still throughout the year, more than a year that this case had been pending, that she had still not found other housing in this case. So beyond just those basic needs issues and the mental health, there's also the challenge with the relationship with these children. The children did not express throughout the duration of this case that they wanted to return to their mother's custody. For the most part, she was a stranger to these children prior to this case. And then regarding the reasonable efforts, cause of error in this case, the parents did not object to reasonable efforts throughout this case. And there is no requirement that reasonable efforts finding be made at the permanent custody trial if those findings have been made in the previous hearings as required by the statute. There is no dispute in this case that those reasonable efforts findings were made by the court throughout the case. There was no objection to any reasonable efforts finding throughout the entirety of the case. But there was evidence still presented at the trial court during the permanent custody trial that reasonable efforts were made. The agency was willing to work with the mother with Phoenix Rising from the outset of the case. The agency had also made referrals to multiple service providers, including the Bear Foundation, Community Health Center. The agency was also providing bus passes and providing its own parenting feedback at the visitation. So there was ample evidence presented at the permanent custody trial that reasonable efforts were made, even though the court was not required to make that finding at the permanent custody trial. And so I see my time's coming to a close, but those were the issues I wanted to respond to here before the court. Summit County Children's Services asked this court to affirm the decision of the court below, because this case, the decision for permanent custody is not against the manifest weight of the evidence. This was not a case where the court had clearly lost its way in finding that permanent custody was in the best interest of these children, and the parents have not made a successful plain error argument regarding reasonable efforts, nor the appointment of an attorney for the children. The wish of the children to have visits with the parents is not sufficient enough to arise to a conflict between the parent and the children as far as custodial wishes. The case law history shows that the children have to express a desire specifically for custody and not just visitation. It would be expected that a child would want to visit a parent, and the case law history shows that that is not sufficient enough to raise a conflict to warrant a child to have an attorney separate from the guardian ad litem. So for these reasons, the agency asks this court to affirm the decisions from the court below. Thank you.
Thank you, Counsel. Counsel, you'll have about 4.5 minutes for rebuttal.
Thank you. I would pick up on the issue that we were just addressing regarding an attorney for the children. And I heard Mr. Campbell say that when custodial history is at stake. But here in this case, it wasn't just when custodial issues are at stake. But here custodial issues were not just at stake. There was also a motion by mother for a 6-month extension. So when the children said, when EG said that she looked forward to visits and enjoyed them, when AG said she was okay with continuing to go to visits, we submit that that speaks to a conflict regarding their wishes in the issues that were at stake at this hearing. And I would also submit that I do not believe that an in-camera ever occurred where the court would hear the children's wishes, and I believe that is prescribed in a juvenile, I think it's juvenile rule 4. Regarding the timing of the filing of the motion for permanent custody, I see that the complaint was filed on March 8th of 2022, that there was an adjudication on June 7th of 2022, that the case plan was adopted on June 8th of 2022, and Children's Services filed its motion for permanent custody on January 19th of 2023, 6 months after the adjudication of the children and the adoption of the case plan. I believe it was in Children's Services brief where they indicated that mother was referred to BEAR for parenting and mental health. And there's that mental health word again. I submit that mother also obtained mental health treatment through the BEAR Foundation with the 4 visits that she utilized with that parenting coordinator and supervisor who gave her coaching and treatment with the children. Interestingly, I also submit that after these 4 sessions, they simply stopped, and we don't have an explanation for why they stopped. In my review of the record, I did not see an explanation in the transcript or in the BEAR Foundation records. So with that, we are respectfully requesting that this court consider remanding the matter and finding that mother did make substantial case plan compliance such that a 6-month extension was warranted in this case, and to consider the other issues that we've raised here. I would also submit for the court's consideration that what must a parent in Summit County do to then obtain substantial case plan compliance? This parent experienced layers of substance abuse issues along with mental health issues, and she was working that case plan. She was not perfect, but she made some, we would submit that she made significant efforts to warrant additional time. Again, she asks that you consider remanding the matter and allow her an opportunity to continue to make substantial efforts that remedy the concerns of the case plan. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you both again.
Thank you.
Thank you.